and real estate and construction sectors. A proven subject matter expert in traditional bank-led project finance, project bonds, and equity investments, with a broad experience advising on structuring funds and corporate bonds, specifically structured to cater to pension funds and other external investors. Abiodu's transactional experience include advising Infrastructure Credit Limited on a 10 billion guarantee to Transport Services Limited with respect to a bond issuance, as well as 12 billion naira infrastructure debt issuance to Cream Liquefied Natural Gas Limited. He served as team lead advising the Central Bank of Nigeria and Nigeria Electricity Regulatory Commission on the 213 billion intervention fund for the NESI, and advising Stanbic IBC as it provides a senior term loan facility letter of credit and import finance facility to Kellogg, the international cereal manufacturing company, for the construction of a cereal processing factory, equipment, and other related infrastructure within a Nigerian free trade zone. Abiodu was admitted to the Nigerian Bar in 2010, received the Nigerian Rising Star Award as one of the top 40 Nigerian lawyers under the age of 40 at the Nigerian Legal Awards 2018. Abiodu would be assisted by Chisotam Akwiwu, who is also an associate in Detail Solicitors. So, distinguished delegates, it is my pleasure to welcome Abiodu Oyeledu and his team. Thank you.
Thank you very much, Mr. Chairman. And just double checking that you are able to hear me clearly on your end.
Loud and clear.
Okay, fantastic. So thank you so much for the invitation to come and speak. I would also like to extend regards to the faculty dean, Mr. Esson, as well, for putting this together. It's a continuing legal education framework, which is meant to assist legal practitioners in terms of exposure to areas of finance. And for today, we'll be focusing on legal due diligence aspect of it. I was privileged to join the sessions yesterday, and I know so far so good. It's been quite educative and enlightening, and I think the speakers yesterday made my work slightly easier, because some of the terminologies that I may be using as we progress would have been explained or clarified in yesterday's sessions. So just a bit about detail. Our practice areas include finance and capital markets, which is the core focus of today, as we'll be speaking about financing specifically. And you'd also find us in other sectors of the business community, such as energy, power, infrastructure, real estate and construction, and tech and digital economy. But at the bedrock of all of this, we're a corporate commercial law firm, which means everything and anything that has to do with businesses is our forte. So to the meat of today's discussion, we're going to be going through a general introduction to due diligence, as well as the role that due diligence plays in financing transactions. And then we'll also talk a bit about how to develop a due diligence request list or information list. And we'll touch on certain areas of concern, AOC, if you so call it, in a due diligence exercise that, would just open your mind up as to some things that you typically be looking out for when carrying out a due diligence under a financing transaction. And lastly, we'll touch on various approaches when you're practically commencing or starting a due diligence exercise. And we'll round off with a Q&A session. And the entire program is expected to last 1 hour, 30 minutes. 1 hour for the slides, 1 hour, give or take, 1 hour, 10 minutes for the slides. And then we would have a Q&A session right afterwards. Just to note for people in the comments box that the slides will be circulated, so it may be useful to pay a bit more attention to what is being discussed in the room. Be rest assured, you will get the slides at some point, if not today, but shortly after the program. That's the entire program as concluded. Okay, so before I go through the slides, just to mention that I would be touching on the introductory bits of it. My colleague Chizotam, who's an associate with the firm, would also take us through some aspects of the slides, and then I will come back in to round off and also take the Q&A session. A due diligence exercise. I'm sure we've heard a lot about conducting due diligence as lawyers, right? It's not something which is totally new to us. It's not a new terrain. You would have heard a lot about due diligence exercise, whether in financing transactions or in other sorts of transactions you are conducting. And in the context of finances, it's essentially a fact-finding process through which you as a lawyer would be advising on an efficient structure for providing, for the lender or a financier to provide finance. And the essence of why you are doing this is so that they can make an investment decision. And your due diligence exercise will end up in what you call a due diligence report, which you have to provide to the lenders. But to break it down a bit granular as to what due diligence is, it's basically, I think the first point of call in a due diligence is understanding the objectives of the parties and your clients in particular. You cannot start off a due diligence exercise until you understand what the objectives of the parties are. And after understanding those objectives, it then is a process of finding out through empirical means, right, what risks are attributed to that investment objective of your client, right? And I say empirical advisedly because it's not a best guess sort of approach. There has to be a method to how information is reviewed and risks or hurdles to the transaction are identified, right? And after identification, also how those risks are mitigated. And it's instructive to note at this point that due diligence and what we'll be speaking about today cuts across all forms of financing. You will hardly have a financing transaction where either the first step or the second step would not involve some level of due diligence. It could either be, a basic due diligence as to just finding out what kind of entity are you lending money to, right? Or in more sophisticated transactions, like the syndicated financings and things, or bonds transactions that Mr. Okafor had mentioned in the session yesterday, right? You then be going through more complicated sorts of processes to identify the risks that are attached to a particular transaction. For your typical bilateral loans or private arrangements that are syndicated, your due diligence will be between your clients, your due diligence reports will be issued to your clients, but for more public sort of financing methods like corporate bonds that are regulated by the Securities Exchange Commission, some aspects of the due diligence may be required to be published for you to make a public disclosure, right? So say, for instance, the claims and litigation profile of the issuing entity that intends to raise funds would be required to be published to investors at large. Okay, so with that background, there are two main components that make up a due diligence exercise, which I've just tried to identify on the slide on the screen. And it is risk identification and assessment, plus risk mitigation. So it is not enough for you to have identified that there is a certain risk to the financing that you are undertaking, right? As lawyers, you should be proactive and go a step forward and say, we've identified this risk to the investment you want to make. You want to invest in company A, right? And we've identified that there is a certain risk that would not enable you to get your returns on your investment, right? So over and above identifying that risk, you then assess the risk and say, okay, this risk, this is the level of danger we see it having on your investment decision. And the last step of that is to say, this is how you mitigate that risk, that it would no longer be an impediment to you closing on this transaction. And the overall reason why you are doing all of this is to ensure bankability of the transaction, right? And bankability simply means the degree to which a project or a commercial transaction requiring finance is structured, that there is an overall acceptable risk to the lenders or the financiers if it is not a debt transaction, right? So whether or not the project is bankable would determine whether or not it is whether or not the lender or the financier would invest in it, take the next step. What would they be submitting to their credit committee? And you should know as well that aside from the legal due diligence, there are other due diligence work streams that typically go hand in hand. So whilst you're looking at the legal aspects of things, some other advisors may be looking at the financial aspects of things, right? So sometimes your due diligence may depend on what is discovered in the financial due diligence as well. Okay, so next slide. So for every financing, like I mentioned, a satisfactory legal due diligence exercise is typically a condition to completion of that financing. So before the lender or the financier reaches into their pockets and bring out money to pay to the company or the obligor, you hear me use the obligor word quite a few times. Obligor essentially means, in very simplistic terms, someone who is obligated to do something. So in this instance, it would be your borrower who has borrowed money from you, who is then obligated to repay, or it could be a security provider who has provided security to money you've lent out that is an obligor, right? And a satisfactory due diligence connotes many things. It connotes knowing where to look. You also need to know, and maybe I should break that down a bit, right? So knowing where to look, right, is perhaps the first step, because once you've understood the objectives of your client, then you understand which areas of the regulatory landscape that governs that transaction you need to look at. So say, for instance, you are working on a transaction to finance something in the power space, right? You automatically know that you need to look at the regulations that govern the power sector. But over and above that, you also need to know what other touch points there are in your transaction. So if you're doing something, if you're financing the construction of a generation plant, automatically you know there's some construction involved, right? So not only looking at the power sector, you also need to look at laws that touch on construction, right? Aside from knowing where to look, you also need to know what to ask. And this is, I should say, the knowing what to ask is a function of your industry and your diligence over time, right? Because these things are not new, they've been done before. So most times it's about understanding transactions that have occurred in the past, where the risks and the hurdles were in those precedents, and then applying it to your own current situation so you know what to ask for. If, for instance, there had been a previous financing in a certain space and you understand that the regulator asks for certain kind of things for a company to operate in that sector, then automatically you know that you need to ask for whatever permits, licenses that the regulator will be asking for. You also need to know what tools to use, right? And you need to know who to ask. Unfortunately, we are in a jurisdiction where information is not necessarily available at your fingertips all the time. There are some regulators that are proactive and make regulations, laws available, on their website. But you could find yourself in situations where you're looking for a local government law, right? I don't know of any local governments that have websites. So sometimes you may need to go to a local government office or district and try and find some law, directive, or policy that is being used and how it applies to the business that you are trying to invest in, so that you can advise your clients accordingly. Another instructive thing is I think real estate, for instance, real estate is oftentimes state specific. So the laws that apply to it would depend on the particular laws. I mean, over and above the Land Use Act, which regulates land in Nigeria, there are some state-specific laws that you may need to go to the actual state where the business is situated or where an asset is situated to be able to give due diligence advice with respect to that asset, right? And after all of this, it's also about knowing how to verify information. So information that is provided to you should not be taken at face value. Like I said at the beginning, it's an empirical process, which means you have to follow a certain process in order to ascertain that you've looked at the information and the advice you are given based on that information would be correct. So you need to know how to verify. And how do you do that? Oftentimes it's about going to a registry where there's a presumption that any information lodged in the registry, say for instance, the CAC, right? There's a presumption in your favor that most information that is lodged at the CAC or the lands registry, are the current status of the asset you are due diligencing. And the objectives of the due diligence, just to wrap up this sort of introduction, is one, to investigate into the affairs of the business you are financing as a prudent investor, because you want to be sure that the money you are putting in, you are able to bring it out. It's to confirm all the facts related to that business, is to assess the potential risks and deal breakers, because sometimes you may not be able to mitigate a risk, right? And you then need to bite the bullet and tell your clients that this risk cannot be mitigated and you may need to walk away. So there are certain deal breakers that may arise during a due diligence process that makes that investment decision no longer bankable, right? Sometimes it's to verify that the transaction complies with investment criteria. So your lender or your financier may have its own in-house sort of checklist of things that are peculiar to them, right? That, if you don't take box 1, 2, 3, whilst it's not a deal breaker generally, it may just be for them something they would not touch, particularly if they are a regulated entity, or sometimes you have some of these development finance institutions who have certain kinds of things they can invest in and certain things they cannot, based on their governing charters and their sort of constitutional documentation. Next slide, please. So, sorry, could you please go back to the previous slide? There was the last point I'll just raise on this is who initiates the due diligence. So oftentimes or most times rather, the financier, the person who is giving out money to the business, will be the one who would typically initiate a due diligence process, because he's the one with money at risk, right? So it's the onus is most times on the financier to initiate the due diligence process and find out what risks are involved, in order to be sure that his money is safe. But some other times you could have the obligor company taking the initiative, right, and starting that due diligence exercise. So if as a company I know that I'm going to be going into some capital raising in the near future, I could decide to engage lawyers that would then conduct a due diligence on my company, right, and provide me with a due diligence report from a neutral standpoint that says, yes, these are the things your prospective lenders or financiers would ask you for. They would want to know that you filed your annual returns. They want to know that you've done your taxes. So before you even go and start speaking to those people, make sure that you've complied with this sort of checklist of things that we've raised for you. And remember, this is the lawyer to the obligor company. So before a financier will be able to rely on such a due diligence report, saying as quote unquote, it's not his lawyer that drafted that due diligence report. Most times in transactions, you would have what is called a reliance letter. And in practice, what this essentially means is, as the name sort of indicates, is that it allows you as the financier to rely on certain representations or advice that the lawyer to the obligor has raised in their report, so that from a liability standpoint, you can always go back to that lawyer, even though he was not, even though you were not his client, but you can go back to that lawyer to rely on his advice. I've seen those reliance letters heavily negotiated because most times law firms want to, as much as possible, restrict the amount of liability that they expose themselves to. So if you're ever looking at a reliance letter, make sure you go through it with a fine-tooth comb to make sure that your exposure is as much as possible reduced. Okay, next slide. So I think I've spoken to most of these things, but I will just go over them again for emphasis as to the role of the due diligence is to provide comfort to your financier, first and foremost. So he knows that the relevant parts of the investment opportunity have been investigated. So I say relevant because this is, I'm speaking from a legal standpoint, which is the focus of today's discussion. But like I said, there will be other due diligence processes which would be happening simultaneously with the legal due diligence exercise. You've looked at the company, you've looked at the products or services of the company, you've looked at the assets of the company, and you've looked at their operational processes. Then, secondly, is to look at risk identification and assessment, like I said, and this then culminates in your risk mitigation strategies and approach. And I think risk mitigation cannot be overemphasized because that is really where I think that is really where that's the sweet spot that shows the difference in your advice as a lawyer, because it's not enough to say this is the law. It's then how you go beyond that to say this is how you can mitigate this risk while still working within the confines of the law. And it's not all the time that the answer to a risk identification would be, go and do what the law says, even though eventually you may end up there. But if you understand the objectives, so say for instance, the objective of your client is to invest in a business within 1 month so that that business may begin to generate revenues by the end of the year, right? And from your review of the regulatory framework that there could be certain licenses you would need maybe further down the road. Not an immediate license it requires, but something you would need eventually. Say, for instance, an EIA that you would need once it starts operations. It would not be, an EIA means an environmental impact assessment, right? Which essentially is you saying this project would not, be bad to the environment and all of that. Now, because you know that your investment objective is to bring in money immediately, and then maybe further down the line when construction of project has concluded and business starts, the project there starts to generate revenue, right? You know that is further down the line, right? It would not be instructive on your part to say, first go and do the EIA before we even, start talking. You need to take a commonsensical approach as to what exactly is required at this point in time. Does it still meet the objectives of my client? And will I still be acting within the confines of the law? Provided that permit or that you need is something that needs to be done further down the line. How can I structure it that the transaction goes ahead without, killing the deal? But not only that, how do I safeguard my client so that in case this risk ever arises in future and this guy is unable to, get that EIA, like I said in my example, how does my client then get his money back at that point? So that's what I mean by risk mitigation. And it's something that evolves. There's no one size fits all. What I was doing just now was transaction structure, right? And where you end up in from the role of the due diligence is that it impacts on how you structure your transaction, right? And also what documentation you use for the transaction, because documentation would always follow structuring. Oftentimes, you see people drafting documentation without having thought through how the structure for that transaction will go. And I do admit that most of what I'm saying will be more particular for sort of complicated or complex type transactions, where it's a simple bank release money to Mr. A, and Mr. A pay me back in 2 months, where it's nothing complicated. Then you may get away with just doing documentation in that way. But if it is for sort of more complex financings and things like that, say you're financing the development of a housing structure, right? Then your transaction structuring needs to come first, because you need to understand how that structure would play. And then you need to fit in documentation that legally caters to the structure that your client wants to use or adopt for its financing approach. And not only the type of document, it also impacts on the content of the document. So I know the team from Ashes yesterday had kind of taken us through the typical sort of provisions that you would have in a facility agreement, right? And what informs some of those provisions is your due diligence process. So the due diligence feeds into the facility agreement, right? So the things you would have as your conditions precedent, right, which are essentially items that need to be fulfilled before money comes out of the pocket, right? So those sorts of things are a function of due diligence. If you know, for instance, that you are lending money to somebody who is who, like I said, wants to develop a block of flats, and your payment is going to come from that block of flats that he has developed, right? One of your conditions precedent would be, let me see your CO to that land. Or rather, your due diligence would be, let me see your CO. If he does not have a CO, right, or he's in the process of getting governor's consent or something, right, your condition precedent would be, providing that governor's consent. You can sign the document, but until you give me that evidence that you've now obtained the governor's consent, because the Land Use Act says you cannot transfer until governor's consent has been obtained. Until you give me that evidence, then I wouldn't be in a position of comfort to lend you money. Other things like undertakings, things. So, for instance, or representations even, right? If for instance, during my due diligence process, I'm unable to determine the existence, right, of certain things. Say for instance, your tax liabilities, right? You're unable to show me evidence that you've paid, and it is something that is important to me for me to make my investment decision. right? I could make a judgment call that you give me a representation that you've fulfilled your tax obligations. And what that means, like the gentleman from Ashos that said yesterday, is that when you get to your events of default, right, a failure of your representations, that's if your representations turn out to be false, then becomes an event of default that permit me to come against you and collect my money, right? And this could be either, debt, equity. Sometimes equity transactions, you have certain representations in an acquisition that permits the equity provider to go back and meet the seller based on representations that have been made in order to be indemnified for any failure of those representations. And like I also said, for housekeeping purposes, so I, as the obligor, I know I'm going to be raising financing. I may choose to carry out an internal audit to ascertain my level of compliance, preparing myself for that potential deal, right? It saves time. It allows the financing process to be shorter, particularly for complex transactions, because then the lender can just come in and say, yes, you take this, you take A, B, C, D, and we can give you the money. Right. Next slide, please. So, getting information, because largely all what I've been speaking about has been how to interpret the information that you have and then provide it to your client. But how do you even get that information in the first place, right? And maybe before I go into a due diligence request list, I'll just speak a bit more generally as to the sources of information that are typically available, publicly available information. We're in the age where you can go on the internet and find out things, right? And this could be things that are deal specific or just general information around similar sorts of transactions. So if I know I'm financing, excuse me, if I know I'm financing something in the energy space, right? I could go online and find out what sorts of developments are happening in the energy space from a regulatory standpoint, which would allow me to advise my clients better. Also, you could benefit from experienced peers. And what I mean by this is there's nothing wrong with speaking to a colleague who has done similar transaction. Of course, abiding by all confidentiality requirements to find out what sorts of pitfalls occur in that sector or that sort of similar type of transaction, and then gain from experience or the wealth of experience in then developing your own due diligence framework or due diligence list, so that the right kind of questions to ask. Because sometimes I say garbage in, garbage out. I think was something that was taught a lot of us at our earlier stages of learning, right? So if you do not ask the right kind of questions, you may not get the right kind of answers, right? Also, sometimes you may need industry-specific professionals to actually guide you on the kinds of questions that you're going to ask. There was a situation where I had to advise on a financing in the shipping sector, right? Where they wanted to do a bareboat charter. They wanted to charter a ship, essentially, right? And this ship was coming from a foreign jurisdiction. Now, with limited knowledge of how shipping operates, right? Particularly in other jurisdictions, it was very useful to get an actual sector specific participant, someone who knew about the shipping industry, to kind of explain, point by point, how ships are bought, how ships are chartered, which essentially means leased, how a ship is registered, what it means for a ship to have a flag, and how that flag impacts on the citizenship, right, of the ship, right? And then that then forms the kind of questions that you put to the person across the table to understand what their how their business is being run, right? But lastly, most of this will culminate in a request list, which is typically the first step in the due diligence exercise, which is sending across an information and documents request list to the obligor or company. And the request list is essentially you as the lawyer asking a series of questions regarding the business or the entity, or the assets the due diligence exercise is being carried out on, right? It's useful to know that most times your initial list is not exhaustive, right? And the more you due diligence, the more questions you continue to ask. So if I ask you for document A, and document A then refers to 3 other documents, I need to see those 3 other documents to see how they will impact on my opinion about document A. I cannot give an opinion on document A in isolation without seeing what other agreements you've signed, which could possibly impact on your obligations or rights under said document A. Next slide, please. Okay, so like I said, garbage in, garbage out. You need to understand how material the questions you are asking are, right? So that you need to determine the scope of information that you're requesting for, because at the same time you can't just give a blanket request and say, give me everything you have, because then the person looks at you and he may have a lot, right, and doesn't know what exactly to give you and ends up giving you nothing. So you need to ask specific questions. So, and this can only be developed by your understanding of what is material at that time to the objectives of your client. And I keep going back to this thing about objective of the client, right? If we don't take anything else away from this training, I think we should take away the fact that the objective of your client, first and foremost, is the starting point. At this training, you probably wouldn't know every single thing to ask for, but it's just to shape your mind as to how. I think it's better to know the how rather than the what to ask for, because the what is ever evolving. But the how to go about it, I think, is the most instructive part of the due diligence exercise, right? And you can only do this with a strong understanding, first and foremost, of the objectives of your client. Also, you must understand the regulatory framework of the transaction. If your client wants to lend money to somebody who operates a transport business, you need to understand how transport businesses work, right? You can't just tell him, oh, well, they seem to be doing well. They have 2 offices in Lagos and Abuja, so, you can lend to them. You need to know what the regulatory framework of that transport company is, what permits they require for carrying out their business, right? Who their regulators are, right? You need to know. Sometimes you even need to be sort of proactive in terms of where is the regulator thinking. The regulator may not yet have issued a regulation, but it could be that he has issued press releases saying we are going to issue a regulation banning this sort of business. So if that is publicly available information, I'm not going to tell my clients that he should invest at the moment. I would say, well, there's this, it's not a risk yet, but there's a potential risk that this could happen in the future. How do we mitigate that risk? So in the event that this person bans this business that they are that you want to invest in, how would you get your money back, right? Is there, which then goes into, structuring. Is there a security behind this financing you are giving, right? Practical understanding of the business being financed is also useful. The type of financing that you are given is would also determine the number of questions or the type of questions you are asking. Say, for instance, it is a secured financing. Then you would want to have more information about the assets of the company that are being charged, right? You want to know what encumbrances that exist on those assets. If it's project finance, I know Mr. Okafor had shared a lot about project finance yesterday and how it's essentially based on contractual rights. Then your due diligence will be heavily focused on the contracts for that project and the contractual rights that are attached to it. If it's some sort of cross-border lending, right, then you then need to look at, repatriation, funds, and, or if there's a licensing requirement in the particular jurisdiction that that your funds are going into, right? Also, the number of obligors envisaged under the transaction would impact on the level of information you're asking. If there's somebody within or a company within the group, not necessarily the company you're borrowing to, but a third-party company that is providing security, then you need to ask questions about that company as well, because you want to know that whatever agreements you have with that entity are equally enforceable, and you can also enforce your rights in those contracts. And lastly, the type of financier or the source of funds would also impact on the questions the materiality of certain questions. Say, for instance, it's PFA investment. If I'm floating corporate bonds to attract pension fund administrators, right? You need to look at what requirements there are in the PFA space. For instance, PFAs cannot invest if you are not up to date with your pensions contributions. So automatically, that would be a question that I would be asking when I know that it's PFA investment that is the objective of my client. If it is a bank that is lending to the company, whilst PFA contributions is excuse me, is a regulatory requirement, it is not a deal breaker in that instance, because the bank can still lend to you. They could tell you, in 1 year, 2 years, want you to, just for good measure, to have, fulfilled or complied with your PFA contributions, but it's not a deal breaker for them. But if the source of funds is PFAs, then it's automatically a deal breaker in that instance. So the type or the type of financier or source of funds is equally important. Next slide, please. So this this slide just speaks to certain best practices when you're preparing your due diligence request list. It should set out a summary of the transaction structure. Again, understanding the objectives is always very key, and it's always good to list it out. You should understand that your request lists are not a one-size-fits-all. So, templates are good, but over and above that, how do you adopt that template to suit your specific transaction? And those are the materiality things I've spoken about. So you need to be able to identify what things are general, what are generally applicable issues, and what are deal-specific issues. So your generally applicable issues would typically be things you would ask for every and any financing, right? And one would be the corporate standing of the entity. I think we need to run along now because we're pressed for time, but just last things to say would be the document should be clear and easy to use. And when in doubt, you should question everything and request for as much information as you can get. And like I said, information provided cannot be wholly relied on. And as much as possible, you need to verify that information afterwards. Next slide, please. Okay, so this is just a snapshot of what a due diligence request list could look like. Like I said, not a one size fits all. And this can take different shapes and forms, right? But it's just a snapshot of what you can be looking at. And as you can see from this example, it's divided into different sections, asking for information on different aspects of a business. So your corporate constitutional issues, your financial issues, and these are things my colleague would come in to speak a bit more about, or asset-related inquiries. Next slide. Okay, so on the areas of concern, Chizotam will just speak to those, and then I will come back in.
All right, good afternoon, everyone. Thank you very much. So Biodun has laid the foundation, and he's made it very clear that you can't possibly know every single thing to ask, but this is just to give you a pointer as to kind of things to look out for. So these are the main major aspects you want to cover in your exercise. So you first of all start with your corporate and constitutional information of the company, of the obligor, its financial information, tax and fiscal compliance, assets, questions around its assets, regulatory compliance, its material contracts, any claims or litigations that it may have pending or threatened, its personnel, that's its employees, its managers, directors, compliance with its insurance requirements, and points on IP. So to start with the corporate and constitutional information, this is it's just to point out the things that you want to look out for on behalf of the financier. So bearing in mind that as lawyers, we all have a duty of care. And so there are certain important things you need to flag when you're doing your due diligence reports or exercise. So corporate and constitutional information covers, you're looking at the company's corporate existence. So it's not enough for the company to have told you that, I'm a limited liability company. You want to go and do your search, ask for the CAC documents, registration documents, to be sure that the company actually exists under law. And when you do research at the Corporate Affairs Commission, you're able to verify whatever information they provide to you. You're able to look through their MEMATs, that is the Memorandum and Articles of Association, to confirm if you need any internal approvals for a transaction. So certain times the articles may provide that you need shareholders' approval to carry out certain transactions. So you just need to cross-check on behalf of the financier to be sure that there are no hindrances against it moving, and if there are any approvals to be obtained, that they are obtained in time. So a third thing that you want to point out to your financier is you want to look at the share capital of the company. So if it's a private equity transaction where your client is trying to invest into a company or buy shares, invest in a company, you want to confirm, can its share capital accommodate the shares that are trying to be purchased? Or does the company need to increase its share capital, or the existing shareholders need to sort of transfer their shares to your clients? You also want to confirm the shareholding structure. So if there if there are 1,000 shares that the company has, who are the shareholders? In what portion do they hold the shares? You want to give your financier as much information as about the company. So they need to know. Nothing is too, too minor to point out or minute. You need to point out who the shareholders are, how many shares they hold, who is the majority shareholder when you look at the company structure. If they're supposed to be, if it's a secured financing where your client is looking to take a charge over the shares, you need to confirm that there are currently no encumbrances over the existing shares of the shareholders. So like I mentioned on the articles of association, you want to check for any restrictions. It's very common for private companies to have preemptive rights or rights of first refusal, things that prevent you from issuing shares to third parties without having offered them to the existing shareholders in proportion of the shares they currently hold. So like Bjorn had mentioned, while a restriction might be a risk, a simple mitigation would be to recommend that the shareholders pass a resolution that waive their preemptive rights. So also you want to point out who the management of the company is. Although you wouldn't find this information, rather you'd find information about the shareholding at CAC, but you may not find information about the character or whether the management is involved in any corrupt practices. Or you need to make sure that your clients is aware that any company they're investing in or borrowing money to is not involved in any corrupt practices that may impede on its own policies as a company. So next is the financial information. So here you're basically looking at the debt profile of the company. So this involves reviewing the financial statements and financial agreements. Financial agreements here simply mean your loan agreements, any security arrangements or guarantees. So here you're just looking out to confirm if the company already has any existing indebtedness. So is it already indebted to a different company? You want to look at those kind of contracts. And the things you want to look out for in those contracts where they exist are what the company's obligations are and any undertakings it's made, either negative or positive. So for instance, if the company you're looking to lend money to has borrowed money from another financial institution, it's possible that that lender may have put in negative pledges that prevent the borrower from raising further indebtedness. It could either be a complete restriction or they might require them to get their approval before they can then go ahead and incur further indebtedness. So these are things you need to look out for and point out to your clients, the financier. You want to look at what the company's obligations are, payment obligations are. So in the example I gave of them already being indebted to a third party, you need to cross-check that the payment schedules and timelines will not impact on timelines your client has, so that the company doesn't have conflicting obligations, in which case most times the first indebtedness will have to take priority, except there's some form of arrangement between both lenders as to how the company will repay its obligations to both companies. If it's a secured financing, you want to look at the charges, you want to look at the assets. So are there any charges that currently exist? Is the company prevented from creating further charges? Or if it can create further charges, what will be the priority between the two secured parties? So that's between the first lender and the second lender. So you need to advise your clients so that they're able to then decide whether they want to either look into other assets or enter into conversations with the existing lender and discuss priority as to whose right to be or whose obligations will be fulfilled first before the other. And like I had mentioned, there might be consent requirements in the existing financial agreement. So you want to check that if there are any consent requirements, that they are duly satisfied, because failing to obtain those consents might actually trigger an event of default under the existing financing agreements, and that would in turn impact on your client's transaction. So thirdly, you want to look at the company's tax and fiscal compliance. So each company is mandated by law to make certain contributions or remittances. So things like pension, employee compensation. So like Bjorn had mentioned, while those may not go to the lifeline of the transaction in terms of preventing your clients from proceeding with, giving the financing that the company requires, because there are statutory requirements and there are penalties that are attached to them. You want to make sure that just for bookkeeping purposes, that the books are in order, that the company is made to comply. And this can be done by way of either a condition precedent, something they have to do before you lend them the money, or a condition subsequent, something that they can do within a certain period of time after you've already loaned them the money. So you also want to look at assets or ask questions around the assets. So there are real assets and there are non-real assets. So real assets, you have things like you have land and property. Non-real assets, you have machine equipment and things like that. So you look at assets in particular when it's a secured financing and your client is looking to secure its interest or protect its interest by taking a charge over certain assets that the company has. And if the first thing you need to look at importantly is the root of title. So it's not enough for the company to say, I have this land in Ikoyi that I want to create a charge over. You have to then confirm, really and truly, are they the owner, or do they have the title to even create such interest in land? Because there's the Latin maxim, which in English is that you can't give what you don't have. And so even when the client or the company provides you with its C of O or deed of assignment, as lawyers, you owe the duty of care to still go and conduct further searches at the land registry, to confirm not only the root of title, but any encumbrance that may not have already been discharged. Because sometimes the companies may not willingly disclose that they've created interest already. And even when they're interested, it doesn't mean your clients cannot proceed. It just means, like I had mentioned, you have to, both lenders will then discuss priority. And it's possible that, for instance, if your client is looking to loan 5 billion naira and the landed property is worth about 100 billion, and the first facility was only about 10 billion, it's clear that landed property can actually accommodate both interest by both lenders. So it's always just giving your client enough information for it to be able to make its own decision so that it's not blindsided. You don't want a case where your client is going to perfect the title to this charge is created and is then being surprised at the land registry to be told that actually this person doesn't own this land anymore, or there's already an existing encumbrance on that land or on the property or whatever assets is being looked at. So Biodo had already mentioned regulatory and compliance, and I'll use the example he gave. If your client is looking to invest in a company that operates in the transport sector, logistics, you need to be sure that they have all their permits and licenses. So where it's a logistics or it's a haulage company, you need to look at, do the drivers have their driver's license, road safety permits. Those are the things that can actually go to the meat of the transaction, because the lifeline of the company is logistics business. And if by law you're not allowed to operate without these permits, and the penalty for operating without the permits is either getting slammed with huge fines, or directors being imprisoned, or it's being seized, or having the operations being instructed to be stopped. If your client is relying on the cash flows of this company to be able to meet repayments and they don't have these permits, you can see that it can directly impact on the transaction, because in that case, you wouldn't want to advise your client to go ahead except those licenses and permits that can affect the operation of the business itself and made conditions precedent. And it's important that they are made conditions precedent, because you need to be assured that they are all in place before you go ahead and put your hand into your pocket and lend money to the company or invest in the company. And apart from permits and licenses, any general legal and regulatory requirements, if they're required to make certain reports or returns to their regulator, it's important that those reports are made. If you're investing in a company that operates in the energy sector, NEC would require that they make certain reports or annual returns. So those things have to be complete. You need to be sure that the company you're looking to invest in or lend money to is fully compliant with all these requirements. So another key thing you want to look out for is material contracts. And so these contracts differ from the financial agreement you spoke about. So I'm not talking about your loan agreements here, or your guarantee or security agreement. We're talking about if it's a project involved, the EPC contract. So that's your engineering, procurement, and construction agreements. Any other agreements that is important to the lifeline of the business. So, like I mentioned, for instance, using the logistics business, any transportation agreements the company has is a material contract. And there are very important things you need to look out for on behalf of your clients and advise them when doing your DD exercise. And the first thing you want to look out for is enforceability risk. So you need to be sure that these agreements have been duly signed. You don't want a case where only your client has signed and the other party hasn't yet fully executed the agreement. You need to be sure that there are no immunities under the agreements that will prevent the company from being able to enforce a right. So, for instance, if it was an agreement entered into with a government agency, you need to be sure that the government does not have any immunities or immunity provisions that allow it to, escape, in quotes, from any liabilities that it may have against the company. You need to look at the governing law, where it's a contract that is governed by a law that is not Nigerian law. For instance, English law. That you need to be sure that English counsel has looked at this agreement and is able to advise on it, because that as Nigerian trained counsel, we can't give opinion on laws of other countries. So you need to look at these resolution provisions. Do they have clear mechanism for resolving any disputes that arise? Where would the place of arbitration or litigation be? What courts, say arbitration, mediation, and all of that. So things that can prevent the agreement itself from being enforced are things you want to look out and flag to your clients. You also want to look at any breaches that may have occurred. So where the company under the agreement has an obligation to say make payments at a certain date, you need to be sure that it's complied with those requirements, because if it doesn't, then there would be penalties that would be attracted. And when it's things around payments, you could have things like default interest or late payment interest. If the company is supposed to make payments at a certain time frame, and the agreement says that if you don't meet that timeline, then for every month or day that they default, they pay an additional pecuniary interest. These are things you want to flag to your clients, because it's all financials and it all impacts on the company's ability to be able to repay when there's a loan that has been issued. You also want to check for any limitation of liability provisions. Like I mentioned, anything that will prevent the counterparty to that agreement that would allow it to escape from any liability that it may have, against the company you're looking to invest in or lend money to. I think you need to flag. So you also look at completion risk. So this is particular where it's a project finance. So where you're looking to invest money in a company that is looking to develop a project. So for instance, build a power plant or a tank farm or those kind of capital intensive projects. You need to look at the completion date. So it's possible that in that case, your client is lending money to this company, bearing in mind the operation date of this power plant, thinking that when the power plant starts to be operational and make money, that is where the source of repayment is going to come from. So if the company or if your client has flagged in its mind that we estimate that it will take them 5 years from receiving this money to be able to complete this project and begin to operate, any changes or shifts in that completion date will directly impact on the repayment schedule. So these are things you need to look out for, that there are fixed timelines for completing the project, and that any provisions to extend the timelines are very limited. You want to limit the amount, you want to limit the instances in which the counterparty or the contractor can start amending the completion dates. You also want to look at any provisions that allow the parties to vary the contract. You want to limit the instances, because you don't want a case where you're granting a loan based on an agreement as it is. If the parties have the option to continue varying the agreement, at different instances, it kind of changes dynamics and the understanding on which your client has loaned the money. So you need to make sure that any variation instances are limited. If there are any delays that are going to be occasioned, that there are remedies for any delay. And it's possible that under the agreement, the contractor can make certain guarantees so that when it's delaying, it pays the a certain payment is made to cater for any losses that can be, or liabilities that can be incurred, or costs that can be incurred as a result of any delay that is occasioned. Okay, so you also want to look at what you call cost overruns. So like I had mentioned, if it's an EPC contract, most likely is going to be a turnkey contract, or rather a financier would be more comfortable with a turnkey contract. And turnkey simply means that by the time the construction is done, all the clients or the company is doing is literally just coming to turn the key and start operations. It's not coming to do anything else. And so the benefit of turnkey contracts is that you're able to estimate on a lump sum for the contract. So you kind of have a fair idea of how much it's going to cost to execute the contract. You also have an idea of the dates that is going to be completed on, and you are mostly dealing with just one person. You don't have to deal with the person doing the engineering designs, the person doing the operations. You're just dealing with one contractor. So it limits the amount of interface, and that's one person you are holding responsible for everything. So you need to be sure that anything that can impact on the timelines of the project or the costs are minimal, or if they aren't, you want to flag them. So these are things that may be considered red flag risk. And we don't talk about the kinds of risk we have. These are things you want to flag to your clients so that they're well aware of it. You also want to look at things that can cause, so when the prices have already been agreed upon, anything that can make the parties go back and review the prices. So if there's a variation or review of the work scope, that will mean that you have to revise the cost. So you need to flag those kind of provisions that would allow for there to be reopening, because bear in mind that your client is making this investment with certain figures in mind or estimates in mind. So they need to be well aware of instances where the prices they have in mind can change. So another thing you look at is performance risk. So given this product I mentioned, it's very important that there's an O&M, there's an operation and maintenance role involved. And so typically this can be done, while this can be done by the project company, it's always best outsourced to a third party who has the competence and is able to take on all the risk that is involved. The operations and maintenance, they go to the lifeline of the project. And so it's important that the project or the project is well operated and managed. If it's a power plant, there's someone who is competent, because if there's any gap in the operations of the project, that will impact on the cash flows, and that impacts on the company's ability to be able to repay your clients. So you need to be able to look out, review the O&M contract with a fine-tooth comb, make sure that there are no gaps in who is bearing the risk for what. Ideally, the company should push all the risks to the O&M contract, to the O&M contractor rather. So these are things you want to look out for. You want to look at things around remuneration, termination, anything that can impact on, I guess speaking in context of the O&M contract, you want to look at gaps between, if the O&M contractor is going to terminate the contracts, there has to be provisions that say that they can't terminate without having a replacement in place, because you don't want there to be any gaps in the operation of the project. You also want to look at what we call force majeure clauses, so things that can impact either party from fulfilling its obligations. A very good example is the COVID-19 pandemic, right, which would have halted many projects from advancing. So you want to flag out, and you want to kind of limit it to instances where it's absolutely beyond the party's control. If the EPC contract is tied to other contracts, you need to be sure that what would constitute a force majeure under one agreement will also constitute under the other agreements. So like I said, for the sake of your financier, you want to be sure that it's limited to instances where it's absolutely, without a doubt, it's beyond the control of the parties to be able to avoid it. You also want to look at demand risk. So if, for instance, your client is investing in a company that's developing a power plant, so there's going to be electricity to be supplied, you want to be sure that there are what we call off-takers in place. And an off-taker is simply a person who buys the end product that is produced. So in this case, the off-taker would be the company that is buying the power that is being produced, or receiving the power that is being produced. And what you want to do is on the basis, so in those kind of contracts, you want to be sure that, first of all, it's long-term, because if your loan to if your client is loaning, or if the lifetime of the loan is about 20 years, right? You need to be sure that the offtake agreement either matches or supersedes this timeline. You don't want there to be a gap where there's no one that is, taking off this product that the company is producing, because then where do you get your cash flows from? So it's important that the term matches or supersedes. You want to be sure that there are things called, there are certain preventive or protective clauses rather. An example is what we call take or pay. So in this offtake agreement, this person is coming to say, I want to buy the power that you're supplying, and I want to buy this megawatt or whatever quantity, or any other example. And what a take or pay simply does is the person is committing to taking a particular unit at a particular rate. And if for any reason they are unable or they refuse to take it, they then have to pay as if they had taken it. So if, for instance, they were supposed to buy 10 megawatts worth about 1 million naira, if they refuse to take that 10 megawatts of worth of power, they then have to pay that 10 million as though some form of like restitution, so putting the company in the position as though the agreement was fulfilled. So that's the protective measure that you can put in place. You want to look around things around termination, compensation. Okay, I'm just going to patch in Bjorn to add a point. Okay, all right, sorry. Just going to wrap through quickly. So you also want to look at things around termination and compensation regimes and things around assignability. So if your client is looking to take security over a particular agreement, you need to be sure that there's nothing preventing the company from assigning the rights it has to. So if for instance, it has receivables from agreements, you need to be sure that there's nothing preventing them from assigning that contract to your client. So Viedo had mentioned claims and litigations. You want to just look at any pending claims you may have that may impact the transaction, where the damages are caught, where the damages that is that's going to be charged against your client or the company rather will exceed the amount that is going to be loaned. It's a red flag that you want to flag. So just look at any pending cases that may impact on the transaction. You also want to look at the personnel. So who are the employees? Who is the manager of the company? In a private equity transaction, you most likely will invest in a company based on the wealth of its management. So you need to look at the managers, like I said, make sure that there are no corrupt practices involved. Just to have a general idea of who the employees are, who the manager of the company you're looking to invest in is. You also want to look at the insurance. So there are insurances that they're required under statutory provisions to be maintained, and also under contracts as well. So be sure that the company is fully compliant. So these things typically would be yellow flag issues because they don't go to the very lifetime of the transaction, but they're good to look out and flag for conditions subsequent. And lastly, you want to just look at where part of his assets include IP. So you want to make sure that, just like with other assets, that they have the root of title, and they're looking to create any charges over these IP rights, that there are no existing encumbrances or charges over this sort of rights. So I'm going to hand over back to Bjorn to take us through the approaches.
Thank you, Chizotaman. So Ben, I can see you're logged on to tell me I'm running out of time.
Yeah, but you're conscious of it, so it's right.
So I'm just going to be very quick. Next slide, please. Okay, so very quickly, this last slide is just to talk about the risk assessment. So depending on what the level of risk is how you report it. So if it's an actual risk, these are typically things that once they exist, it's unlikely that you get your money back. So those are typical actual risks, and they're mostly called red flags. Potential risks are oftentimes things that if an event occurs or fails to occur, then there would also be that risk you don't get your money back. So those are potential risks that have not yet occurred but could potentially occur. Minor risks, things that, they are minor issues but may not impact on the ability for you to get your money back. And then no risk at all is typically used for things that, the borrower or entity is compliant with, right? And then in your report, you need to find a process of stating where each of those things you identified, which bucket they fall into. For the forms of reports that you typically have, this depends most times on what the client wants. So if he wants a red flag report, then you know that he's asking for just the actual risks, right? So things that are on ground now that will stop this investment from happening. Just give me just those risks. And sometimes it may ask for the long form reports, meaning you have your actual risks and then all the other things, potential risks, minor risks, no risks. And sometimes these reports may come in stages. So as the financing transaction is going on, your client could ask you for interim reports, right? So you issue one report. As you get more information, you update that interim report, which eventually leads to a final report, right? And most times it's best to structure your report in three sort of buckets. So your executive summary, which kind of summarizes most of the issues, the main body of the report, which has everything you've reviewed, and then schedules that you want to refer to. And lastly, I'm just going to touch on verification processes. Like I said, everything you've reviewed should always be subject to some form of verification. And we have several registries that govern different kinds of assets or entities in Nigeria. And on this slide, we just decided to list a few that you most times have to deal with when doing a due diligence. I don't think we need to touch on those because it's quite self-explanatory. CAC for corporates, NEBSA is a free zone entity, LANDS is a central registry in each state for real estate assets, the National Collateral Registry for movable assets, port registry, trademark registry, and the aviation and Nigerian ship registry. And so with that, I think that's the last slide. We can move to the Q&A session.
Thank you. Maybe I'll lead over to you. Not too many questions, so we'll take them quickly before we get Ade on board. So you finish, I do the thank yous, then get Ade on board. Thanks.
Very well. Good afternoon, our panelists. Thank you so much for taking your precious time. Indeed, your training has been very insightful. There's hardly any sector where we don't have financing, and it's been really interesting. This explains why a lot of the comments in the chat box are filled with profuse thanks, and they all want to have your slides for this training. I'll ask a question from an anonymous attendee. It says, in respect of the flour mill and Honeywell's significant acquisition deal, it was in the newspaper that EcoBank raised caveat emptor for flour mill Nigeria's shareholders, noting they were winding up proceedings, given Honeywell's indebtedness. What are your comments as per due diligence in this specific instance? I guess Biodun might want to take this.
Mabel, I think because that matter is currently before the court, we wouldn't be able to speak to it specifically, right? And I don't think this is the forum for that. But we could, just speak tangentially around things of that nature, right? Which is that, oftentimes, like I said, you could have identified a risk and then you could have built into your transaction certain mitigation steps on how to deal with that risk if and when it comes up. So sometimes you could foresee that something may occur, and then build in steps on how to deal with it.
Thank you. There's another one here from, again, an anonymous attendee. In what instance, practical example, can a limitation liability apply for the company?
Okay, so limitation of liabilities in contracts essentially mean that even if I have an obligation and I end up being liable to you, I am providing a cap as to the amount I'll be liable to pay. It could be in terms of indemnities or damages or whatever, right? So say for instance, you are lending to a counterparty to a construction contract, right? The contractor could decide that even though I may have liabilities to the project company, I'm only going to limit my liability to the extent of the contract price. And this often happens in practice because the contractor wants to know that I'm only exposed to the amount which you would have paid me in any way in this transaction. So in that situation, the lenders need to know that the amount that the contractor has decided to limit his liability to, right, that cap, would it be sufficient to pay off any exposure they have to the project company if there is a failure by that construction contractor to complete his project? So that's just a practical example, but it could happen in any kind of contractual relationship where the counterparty to the borrower limits his liability. You then need to look at the cap to say, is that cap, is it something that is normal for transactions of that nature? And secondly, would it be enough to take out the exposure of the lender to that is the counterparty?
Would your position be different if the liability, the limitation liability here applies to a debtor company? In other words, can a debtor company limit its liability?
I'm not sure the context in which that question is asked, but if you are a debtor, you cannot limit your liability to the lender. If that's the question that is being asked, right? If I'm lending you money, there's no way you can limit your liability. So it doesn't happen in the context of the facility agreement. It's, we had spoken about project agreements and other material contracts that the person you are lending money to is actually using to carry out its business. So it's in those sorts of agreements that you find limitations of liability. But a debt is always a debt. If I borrow you 100 naira, you cannot tell me that you want to limit your liability to 50 naira. You have to pay me back my 100 naira.
I actually don't see how you can limit liability as a debtor company when you have penalties running if the interest accrues and it's not liquidated. Theophilus says, how much of liability can be waived by the representation and warranty section of the contract, given the likelihood of withholding facts?
Could you take that question again, please?
How much of liability can be waived by the representation and warranty section of the contract, even the likelihood of withholding of facts?
The question is not very clear.
But it appears it's speaking to limiting liability that may arise from your reps and your warranties.
Okay, understood. Well, in most financing transactions, but for debt financing transactions, right? You cannot limit your liability. I think I should come from that angle, because your exposure to your debt financier will remain your exposure, principal and interest. But for equity sort of transactions, right? If you have an indemnity, if you have a liability to the purchaser or the acquirer, right, who pays you money, you may decide to also, in that instance, put a limitation of liability in your transaction with an equity financier. So there could be situations where I've made a rep as to the kind of assets I'm selling you, that is free and clear of all claims and all of that. And I could decide that, I'm limiting it to the contract price for you to come against me 1 or 2 years on the basis of those reps and warranties. So yes, that's a contractual issue that could arise in equity transactions, but unlikely to arise in debt financing transactions.
Right.
I think we'll have to stop here.
Okay.
Yeah, I will just pass the time allocated for this particular training session. However, it will be remiss of me not to say a huge thank you to Abiodun Oyeledun and Chizotam Akwiwu for a very interesting and insightful presentation. I mean, just thinking about how simply the paper has been delivered and speaking to all the issues within the time allowed, I think is remarkable and commendable. I thank you very much for your time. I thank you for your commitment to the bar, and especially for the fact that you've left what you have to do, spend some hours before now to prepare for this, and also to for the coordination around it. We're very grateful to you, and we hope that again we'll have another session where we could we'll have you as resource people. Thank you very much. We're grateful.
No problem, Mr. Ojibwe. Always happy to answer the question.
Thank you very much. So now we'll be moving to the second presentation for today, and we'll be looking at legal opinions. It's expected that this module will cover a legal practitioner's role in financing, the forum and content of legal opinions customarily delivered in finance transactions, rationale for delivering legal opinion, and the potential liabilities for lawyers delivering such opinions. Now, it is my pleasure this afternoon to welcome Ade Musuro. Ade is a senior associate at Bracewell LLP, an international full-service law firm headquartered in Houston, Texas, USA. Ade's practice focuses on international energy and infrastructure, project development, and project finance transactions, with a particular focus on the Middle East and Africa. Ade has represented various sponsors, lenders, and contractors active in the power, renewables, oil and gas, transport, water waste, and wastewater sectors. I mean, it's interesting because at the moment I'm working on a few transactions with Ade's colleagues at Bracewell, so I know they do a lot of stuff in Nigeria. So Ade, pleasure to welcome you, and the floor is yours.
Thank you very much. Can I just confirm that the slides will be put up, or do I need to share my screen to put up the slides?
It'll be good if you share your screen, if you can.
Sure.
I think you're enabled to do so, so it should be fine. Great, we can see it.
Can I just check that you can see it?
Yes, we can, we can.
Okay, fantastic. Thank you very much. Good afternoon, all. My name is Ade Mosuro, as has been said, and I'm a senior associate in the project development finance practice of Bracewell LLP, and I'll be leading today's session on legal opinions in finance transactions. Please, if you can't hear me at any point, please let me know. And I just wanted to reconfirm that you can see the first page of my slides. if I can just get some feedback that you can indeed see.
We can see it. We can see the first pages.
Okay, fantastic, fantastic. I've intentionally made the slides dense with text, including actual drafting and language typically included in legal opinions, so that the slides can be a point of reference even after the training. Please do reach out to me or the facilitators for a copy of the slides. In terms of Q&A, I believe we've allocated about half an hour at the end of the training sessions for any questions you might have. So moving on to the next slide, just to talk through today's training outline. We're going to start off, I'll give a brief introduction to myself, my practice, my firm, very quickly, followed by a general overview of legal opinions and what is typically covered in legal opinions and why. Next, we'll run through the anatomy of a legal opinion. And then finally, we'll look at the three main sections of a legal opinion with some examples, namely the opinions themselves, qualifications, and assumptions. As I mentioned, there will be a chance to ask questions and share any deal-specific experiences anybody might have at the end of the presentation. So Bracewell is a full-service law firm, as my colleague said, headquartered in Houston. We have international offices out of the US as well. Mostly we're known for our oil and gas infrastructure expertise. And here in Nigeria, we do a lot of work, and we have clients ranging from Seplat, Total, Moral and Proms, Stanbic. Yeah, so we're very active in the region. We're very active in Nigeria, and I'm actually currently speaking to you from Nigeria. So we spend a lot of time on the ground. So in terms of moving on to the content of today, what is a legal opinion, and what is typically covered in legal opinions. So a legal opinion really is borrower or lender, as the case may be, about or legal analysis of a particular aspect of, it could be a finance transaction or a corporate transaction, but in the context of this presentation, a finance transaction. And the main purposes are to state the conclusions of law, typically the borrower or the concession giver, but an obligor or a guarantee provider within a finance transaction to enter into and perform its obligation under an agreement. Typically, the facility agreement, the common terms agreement, the EPC contract, or otherwise. So with this is typically known as a capacity and authority opinion. Secondly, the main purpose is to inform the addressee as to the legal effectiveness of an agreement, and that is typically known as an enforceability or LBV opinion, that is legal, binding, and valid opinion. Sometimes counsel or authorized the legal risks that evaluate. For example, for the purpose of this session, we will focus on the capacity and authority opinions and enforceability opinions, as these are the most common types which you're most likely to come across. Typically, the legal opinions are required to be delivered as a condition precedent to financial close. And aside from the legal opinions being delivered to the financiers on either a corporate financing or a project financing, we also see legal opinions being delivered, for example, to the project company. by the procurer in a project finance transaction, or the off-taker under a PPA. Or, for example, you have a big construction project, the owner would typically require a legal opinion by the EPC contractor under the EPC contract. In terms of what is typically covered in a legal opinion, this really depends on the type of legal opinion being provided. But as we mentioned, the capacity and authority of the obligors within a capacity and authority opinion, this would essentially confirm that each of the relevant obligors, so that is the borrower, the guarantors, and any other obligors under the finance documents are validly existing and properly incorporated, have the corporate power to sign and perform the transaction documents, and the necessary corporate actions have been taken to authorize the signing of those transaction documents by and on behalf of the obligors. In terms of legal effectiveness of the transaction, i.e. speaking to the enforceability opinions, this would confirm that the transactions create, or rather the transaction documents create valid, binding and enforceability obligations, subject to the necessary qualifications, of course, on the obligors. And later on in the presentation, we will take a deep dive into these qualifications that I refer to. And lastly, governing law and jurisdiction. This would confirm that the law chosen to govern the documents and the jurisdiction chosen for settling any disputes are valid choices. And depending on the dispute resolution mechanism in the underlying document, this would be tweaked to reflect either the litigation choice or arbitration, as it were. As a matter of practice, we usually find that, especially in common law jurisdictions, lenders' counsel would typically provide the enforceability legal opinion. And counsel appointed in the place of incorporation, i.e., for example, if you have a Nigerian company, you would have Nigerian counsel providing the capacity and authority legal opinion, whether the Nigerian counsel was borrower or not. But there are exceptions to this general sort of convention. In the US, for example, the borrower's counsel will typically be required to provide all the legal opinions and not the lender's counsel, including the enforceability opinion. One related observation is that although in a traditional sense, a capacity and authority opinion should only cover pure capacity and authority, we have seen in recent trends in the market to have a more quasi-opinion sort of straddling both capacity, authority, and enforcement opinion. So, for example, some lenders, such as the big export credit agencies, such as JBIC, have requested to have opinions with respect to the ranking and enforcement of arbitral awards in the capacity of an opinion, or the ranking and enforcement of security in a capacity and authority opinion. So the scope, depending on your transaction, really is not always limited strictly to either capacity and authority to enforceability. So it's never really depending on your transaction, one or the other. So moving on to the next slide, if I can just confirm that you're with me, and it's just not just me talking to myself. We're currently looking at slide 7, the anatomy of a legal opinion. Can I just confirm that you can see the slide and you're following me?
We're following you, Ade. We are.
Thank you very much. Okay, so with regards to the anatomy of a legal opinion, I'm now going to take us through really most of the key core sections that you would find in a legal opinion. And I've included, like I said, within the drafting itself, actual sort of, or rather within the slides, actual drafting of what you would expect to see within these provisions of a legal opinion. So starting with the addressees, in the context of a financing, this can either list the number of participants, or rather, sorry, either list the number of parties to whom the legal opinions is addressed, or if you, within your finance documents, your CTA, have used terms like secured finance parties or the equivalent, then the addressee section would simply refer to the secured parties. So next you have the preamble, and this would typically cover details of the incorporation of defined terms, for example, from the CTA or any other applicable document. The next section would typically be a list of documents examined, and this covers the relevant transaction documents being opined on. And in the case of a capacity and authority legal opinion, the constitutional documents of the obligor. This is either inbuilt into the main body of the legal opinion, or if the list is extensive, it can be put in a schedule. Distinction is typically made if the documents have been cited in the original or whether they are PDFs. Next is the scope of the opinion. This is mainly included from a liability perspective and makes it clear that, for example, you will not have investigated into the laws of any other country other than the laws of Nigeria, for example, with respect to which you opine on as applied by the Nigerian courts, and in effect of the day the opinion is being given. I think it's important to stress that for the purposes of this presentation, we've obviously included reference to Nigerian law and courts in Nigeria. However, the same sort of construction and consideration would be expected from any other governing law legal opinion. So if you're working on a cross-border transaction involving English counsel, involving Ghanaian counsel, for example, you would expect to see the same things, but in relation to the relevant choice of law or jurisdiction in which the legal opinion is being given. So moving on to the next slide, dealing with assumptions. All legal opinions should include assumptions. And these will typically relate to matters which cannot be checked without an unreasonable level of inquiry. So essentially being matters of fact. And often certain of these items will be addressed by way of representations and warranties in the underlying transaction documents themselves. Moving on, the crux of the legal opinion are the legal opinions themselves. And these are limited to specific questions of law and not questions of facts. As mentioned, matters of facts are covered in the underlying documents themselves. The next part of the legal opinions are the qualifications. And we will go into detail, looking at the opinions, qualifications, assumptions in detail later on in the presentation. But with respect to qualifications, these relate to matters of law which qualify the legal opinion. For example, effects of insolvency law, which is jurisdiction specific. And it's interesting because we have seen and I have seen legal opinions being tendered by law firms in Nigeria without qualifications, without assumptions, so completely clean legal opinions as to either capacity, authority, or enforceability. And that really shouldn't be the case, because it is virtually impossible to give a completely clean opinion that this document or this this obligor has complete capacity and authority, because there will be a level of assumptions and qualifications that would apply and would affect the opinion that is being given. But we'll talk about that in a bit more detail later on in the presentation. Lastly, we would typically see a section in the opinions for reliance and disclosure. And as a starting point, I would suggest that counsel include a statement to the effect that the legal opinion is given for the sole benefit of the person to whom, or rather persons to whom, the opinion is addressed. In a syndicated financing, it may be, it may be on a case-by-case basis, be relied upon by an entity that perhaps later becomes a lender, and what the opinion will state is it will give a time frame for that. Typically in a syndicated project finance transaction, you have a window of anything between 6 to 10 to 12 months, following financial close for the club of lenders at financial close to syndicate, or the mandated lead arranger to further syndicate the facility. And each law firm's opinion committee should really determine the scope of disclosure on a non-reliant basis. But by way of guidance, what would typically be permitted is to affiliates of the addressees, directors, officers, employees, professional advisors, auditors, insurance, reinsurers, or even reinsurance brokers. Disclosure would also typically be permitted to anyone to whom disclosure is required pursuant to any court order, and or any supervisory or regulatory body following request in connection with judicial proceedings, or as is required by law or regulation. One point to note is that banks may have, or rather lenders, so not just banks, you have DFIs, ECAs, anybody sort of acting in the lender capacity may have an internal checklist of policy requirements, and there may be specific wording relating to disclosure that is required. I think from a transactional management perspective, it's important to agree the reliance and disclosure language in the context of one legal opinion, and then ask other counsel advising on the transaction to replicate rather than negotiating each one individually. I think it's also important to, and I haven't noted this in the slides, but I think it's also important to note that typically from a transaction management perspective, legal opinions are typically left till last minute because there are CPs and you're busy negotiating the finance documents, you're negotiating the actual commercial matters within the opinion, within the wider transaction itself. But I would implore us all to really try and get legal opinions out of the way, or at least have agreed drafts out of the way as soon as possible. And it's often one that can be run in parallel to the negotiation of the main transaction documents. You know, it's one that, you know, you could easily have one of the sort of perhaps junior lawyers, you know, the associates just pick up, because typically this is left till the very last minute, and then, you know, the documents are ready to be signed, and you find that sometimes there is a wide sort of gap between the expectations of what the parties expect to see in a legal opinion and what the relevant and respective counsel are happy to give. Another point that I'd like to flag, which is not explicitly noted in the slide deck, is that certain searches typically have to be done before a law firm will issue a legal opinion. So, for example, with the capacity and authority opinion, in Nigeria, for example, we have the CAC. And to give a capacity and authority opinion, you would have had to carry out a search at the CAC against the obligors to confirm that they are properly registered. And you all probably know this better than I do, but you would also need to carry out a search to confirm that the obligors are not subject to any insolvency proceedings. As part of giving the opinion, you would need to carry out a search to identify who the directors, the identity of the obligors directors, or any authorized signatories, as well as provide details of any mortgages or charges registered against the obligors which remain undischarged. And this is important if there is a security package. So now turning to the next slide, actually looking at the opinions that are given. So as we've just been discussing, due incorporation and status, actually, I think, you know, we're not going to go through all possible opinions because really, you know, it's important to just touch on some of the most pertinent ones, covering capacity and authority and enforceability opinions, which is what, you know, 9 out of 10, in fact, 10 out of 10 transactions, you would need finance transactions, you would need those two forms of legal opinions, operation and status. What we are saying here is the obligor is the type of company incorporated and is validly existing under the laws of its country of incorporation. And if any of you are providing such a legal opinion, it would be under the laws of the Federal Republic. So for Nigerian companies, you would need to run the searches you have previously mentioned. But if you're reviewing the legal opinion from sort of counsel advising on any international companies, really sort of these are the same things that you would want to look out for. Secondly, we would expect to see a capacity and authority opinion, which confirms that each obligor has the power and legal authority to enter into and perform its obligations under the transaction documents to which it is a party. And each obligor has taken all necessary corporate actions to authorize the execution, performance, and delivery of the transaction documents to which it is a party. Counsel should remember to check against the constitutional documents and the resolutions for the obligors when providing such opinion. For example, the board resolutions, the shareholder resolutions, the articles, the MEMS, just to ensure that they have actually the capacity and the authority to enter into the transactional documents, and no additional step or requirement is applicable. And this ties in with the fact that usually counsel, given the capacity and authority opinion, would be required to either review or draft the corporate authorizations that are required for entry into such transaction documents. Third, we have the non-conflict opinion, which essentially confirms that the execution and the performance by an obligor of its obligations under the transaction documents to which it is a party will not contravene its constitutional documents or violate any provision of Nigerian law where applicable. Excuse me. Nigerian law applicable to companies generally. Each obligor should have power under its articles and memorandums to carry out the transaction, whether it's borrowing, granting of security, or providing guarantees, and there should be no restriction on such rights. Fourthly, you typically expect to see an opinion on validity, and this simply confirms that the obligation of each obligor under each Nigerian law transaction document to which it is a party constitute legal, valid, binding, and enforceability obligations of such obligor. Of course, LBV opinions and enforceability opinions being provided by ourselves, Nigerian Council, will only be in relation to Nigerian law governed documents. So you can provide a capacity and authority opinion in relation to a Nigerian company entering into a New York law or English law governed document, but you wouldn't be able to provide a LBV opinion or rather an enforceability opinion in relation to a Nigerian company entering into a foreign law governed document. So moving on to the next slide, further opinions here. The next two legal opinions deal with security interests being valid and registration, so would be included as appropriate. With respect to choice of law, this is to do with the choice of law being given effect by the Nigerian courts, for example, and can cover Nigerian law in Nigerian law transaction documents and foreign law in non-Nigerian transaction documents, as the case may be. In the case of foreign law, however, you would need to include a proviso stating that such foreign law is pleaded and proven in the Nigerian courts as applied by Nigerian law. And this really is a type of qualification that you would include in the legal opinion, which we will get to shortly. Next, we would expect to see an opinion with respect to submission to jurisdiction. This is included if there is a Nigerian court jurisdiction, either exclusive, non-exclusive, or one-way exclusive. However, if arbitration, and is likely to be the case in most of the big financing transactions we work on, if that is the sole dispute resolution mechanism, or if there's an option to arbitrate, then you would modify this wording accordingly. Moving on to proceedings, the last row on the slides. This is to do with application of proceedings brought in a court of competent jurisdiction in Nigeria. It is only required where the submission to jurisdiction opinion is given and where the parties have submitted to the jurisdiction of the Nigerian courts. The latter part of the opinion already includes some qualifiers, e.g. if the competent courts is of the view that the courts of another jurisdiction are a more appropriate forum. So you would expect to see that as well. Moving on to the last two opinions, this deals with ranking, to do with the pari passu ranking of present or future unsecured and unsubordinated indebtedness of the obligors. This is something that we would typically expect to see, as well as financiers in a secured financing. The last one, immunity, isn't one that often comes up. Really, it depends on whether there is a quasi government entity that you are dealing with in the context of the transaction, perhaps a procurer or a concession giver. But the immunity opinion states that the obligor and their respective assets are not entitled to immunity from suit or enforcement of a judgment on grounds of sovereignty or otherwise in the courts of the Federal Republic in respect of proceedings against such obligors in relation to the transaction documents. As I said, this opinion is only typically given if appropriate or relevant within the parties of the transaction. So moving on to the next slide, dealing with qualifications. So some of the key common qualifications, which I mentioned previously, relate to matters of law, and which are to be considered in conjunction with the opinions being given, relate to most commonly searches, insolvency, bankruptcy, or similar laws affecting the parties generally. Starting with searches, we would typically expect a qualifier for the fact that even though a search may be done, it may not be complete and up to date. From for example, a security perfection perspective, typically there's a period of a number of days to register a security interest from the day that it is created, and it may be that such period has not elapsed or has not lapsed at the time the search is being carried out. So you would typically want to include a qualifier to this effect. Secondly, you have insolvency. There would typically be a general qualifier for all insolvency, bankruptcy, or similar laws affecting the rights of creditors generally. The reason for this is that the effectiveness of security interests and enforceability of contracts may be affected by restrictions arising from applicable insolvency laws, which affect the enforcement of creditors' rights. Moving on to the next slide, dealing with the next set of qualifications. You have enforceability related qualifications as a category. This is mainly to highlight that notwithstanding, we use the term enforceability, or rather enforceable, certain rights and obligations may be qualified really by, the lapse of time or the non-conclusivity of certificates. And really, these qualifications are standard and rarely resisted. And, we would typically expect to see them in any opinion being given by legal counsel in such a sort of big financing. For example, an obligation, you'd expect to see a qualification which states that an obligation to negotiate or enter into further agreements may not be enforceable. An agreement may be amended orally, in writing, by parties thereto, notwithstanding any provision in the documents to the contrary. Remedies such as specific performance and the issue of any injunctions are available only at the discretion of the court. And fourthly, moving on in the slide deck, is one of priority of security interests. And priority of security really depends in most instances on facts. For example, priority as between successive security assignment of debt really is determined by reference to the time at which notice of the respective assignments was given. And a statement in a security document to the effect that it is to be first priority will not in itself make it such if the rules on priority provide otherwise. Just to reiterate that, a document may state that it is a first ranking charge, first ranking mortgage, but really you would need to have a qualification in your legal opinion as to the enforceability of that document to state that it is subject to the applicable laws on priority that govern, that document, which would in most instances be, when was notice provided as to the creation of that security interest. Moving on to the next slide, assumptions. So in relation to assumptions, these are, as we said previously, matters of facts, and we aren't going to go through all of them. The large majority of the assumptions are self-explanatory, but sort of just taking you through a few of them. I know that we have only about 15 minutes left for the presentation. So with the assumptions, for example, you would want to assume that all documents that have been reviewed by yourselves in extract do not reveal a misleading view of the document as a whole. And what I mean by this is sometimes, you have only been provided with an extract of a board resolution, for example, which confirms authority and the fact that the relevant board members have voted in favor of entering into transaction. But that board resolution that you've been provided with is really only an extract of the entire document because, for example, there might be commercially sensitive matters not related to your particular transaction. So in such a circumstance, you would want to include an assumption which stipulates that the extract you have been provided does not reveal or provide a misleading view of the board resolution as a whole. Also, you would want to include an assumption which stipulates that the entities other than the obligors who may be opining, who you are opining on, have the power and legal capacity to enter into their documents, and this wouldn't be contrary to applicable law. So what I mean by this is, for example, you have a Nigerian company entering into a contract with a Danish or a Finnish or a Delaware company. You would typically want to include an assumption, and assuming you're given an enforceability opinion on a Nigerian law-governed document, which is being entered into with the Nigerian company and a foreign company. You need to include within that an assumption which stipulates that the entities, the counterparties to the obligors on which you are opining have the power and legal capacity to enter into that document, because that's the only basis on which really it would be enforceable, and that wouldn't be contrary to the applicable laws to which it is subject to. I think, you know, the solvency and absence of insolvency process, you know, I think we've spoken to completeness, I think is self-evident. Signatures, yes, I think that's self-evident. So moving on to the next slide, I think board resolutions and directors' duties is also self-evident. You know, directors are often subject to obligations that are imposed by law. So you would want to include an assumption in there that the directors of each obligor have acted in compliance with their duties under applicable laws in relation to the approval and entry into the transaction documents to which the obligor is a party. So in terms of other laws, which is the final role here, the purpose of this is to assume that all the obligations of all parties, other than those being opined on, and this is similar to the assumption we discussed earlier on, are legal and enforceable. In addition, it is to assume compliance with all relevant overseas laws, which you are not opining on. And this may be relevant, for example, if there is a non-Nigerian party entering into a transaction document, and we really need to assume that there is nothing in its home jurisdiction that would affect its entering into the Nigerian law governed agreement. I think this is very important. As I mentioned, you know, we've seen several transactions being given by several transactions in which opinions are being given by legal counsel here in Nigeria, by law firms in Nigeria, where, you know, you just have clean opinions without assumptions or qualifications. And this really, from, you know, a legal perspective, is not something you want to do, because it can open you up as counsel to potential liability for negligence if you are given these opinions without the relevant qualifications or assumptions. Moving on to the next slide, we have a series of other assumptions which are stated therein relating to improper conduct. So, for example, you know, you'd want to include wording which states that each party entered into the transaction document in good faith on an arm's length commercial basis. There has been and is no bad faith, fraud, coercion, duress, mistake, or undue influence on the part of the parties to the transaction documents, and the transaction documents have not been entered into by any party in connection with money laundering or any other illegal activity. And all of this is really sort of important, really, because it qualifies and, you know, carves out the scope of your liability when given these opinions, because, you know, the standard that is imposed from a legal practitioner and, you know, your insurance, you know, most importantly, you know, your professional indemnity insurance would expect that, you know, when giving out opinions for which you may later be held liable, you have sufficiently qualified and put in the right assumptions in place. The balance of the opinions that, or rather the assumptions that I've included in the slide deck, deal with other dealings, searches, which we have discussed previously, and for example, entry into agreements. So that really concludes today's presentation. I think I've done it in good time with sort of 9 minutes to spare for the substantive part of the presentation. So now, I'd like to open up the floor to any questions that you might have, and please do let me know. One thing I do want to flag also is that at the end of the presentation, I have included my contact details in the final slide. So please do connect with me on LinkedIn or drop me a line and let me know if I can be of any assistance after this presentations. But please do let me know if there are any questions at this stage.
Thanks a lot, Ade. I'll just invite Mabel to take the question and answers, and then I'll come back later to close. Thank you. Mabel, are you there?
Sure.
Hello, Mabel. Okay. Piers Mabel is. I'm just trying to get to the questions that relate to you Ade, because I can't find Mabel at the moment. So let's see. So I'll start from the very bottom now. So Ade, Ibrahim Bello wants to know, please, what is the goal of providing legal opinions?
Okay, sure. So typically, as I mentioned in the first slide, a legal opinion does a number of things. And in the context of a large financing arrangement, typically you would have the lenders, for example, require capacity and authority opinions or enforceability opinions to give them assurance that from a legal perspective, the parties that are entering into the agreement from a capacity and authority opinion perspective actually are able to enter into those agreements. Number one, that they actually exist, that you're not dealing with a company that does not exist, so you're actually dealing with a proper corporate entity, or you are or rather they have the power and authority to enter into them. Closely related to that is that the directors of the, or rather those who are purporting to sign on behalf of the particular company actually have the authority to do so. So they're properly sort of registered and appointed directors in accordance with the corporate constitutional documents of the company as is registered with the CAC. So that's the purpose and the goal of providing a legal opinion. So it is something that is often required by financiers or owners of large construction projects. It is all, and I understand that you just did the due diligence session before this. It is really all part of providing comfort to those who are taking risk that, the relevant obligations under a contract can be performed and can be enforced. I hope that's helpful, and I hope that's answered your question.
Thank you very much for that. I mean, I think you broke it down very well. I think perhaps what they're also looking for is just to know that it's a certification that a lawyer provides to help the transaction move on. But thank you very much for that. And Mabel, I think you're here.
Yes, I am.
Want to take over? I couldn't find you for a bit. I finished a bit earlier, so I took the very last question. If you want to take the rest, then yes.
All right. Thank you very much. And thank you, Ade, for your presentation. It was brilliant. Masi Ipa says, can we have a simple or a draft of a legal opinion?
So what I've done with my slides, which I'd sent to the administrators previously, is that the the body of the slide itself, you would have noticed that I have included particular drafting and language that would be included within a legal opinion, starting from the anatomy of a legal opinion, the opinions, the assumptions, the qualifications that we would typically expect to see. So the slides should really give you the structure of a legal opinion in terms of the anatomy, and then you can literally just lift off within the body of the slides, the sections dealing with opinions, assumptions, and qualifications, the wording on the right that I've included in there.
Thank you.
I hope that answers your question.
I think it does. To what extent can a legal practitioner be liable on a legal opinion?
So this is, I think, a very valid question. And, as a legal practitioner, the assumption or the expectation or proper good practice really is that we are all operating either as sole practitioners with the relevant professional indemnity insurance as required by the NBA, or under the guise of a law firm. A law firm is definitely liable for every single opinion that it provides. And within, the context of a financing, really your liability is that of, whatever is applicable under sort of normal contractual law principles. So whatever loss that is incurred by the addressees of your opinion, as a result of your opinion being incorrect, you are liable for as the law firm. I don't know what common practice is here in Nigeria, but typically I think the gold standard would be that the firm is liable, and you as an employee of the firm, obviously if you're a partner, then you share in the liabilities, but as an associate or otherwise, really your liability is is minimal. Your liability is your job if you mess it up, but as a partner of a law firm or the law firm itself, then your liability is up to whatever loss that is suffered as a result of your opinion being incorrect or not qualified appropriately. I believe that some law firms put in additional liability caps within their opinions, but typically in a large scale international financing, it really is the whatever loss, the size of the facility, for example, that is being offered, that is what is at risk.
So I'll just make the point that it's pretty much standard practice for especially big international finance organizations to ask that law firms maintain a certain level, in Nigeria, maintain a certain level of indemnity in order to handle certain transactions.
Correct.
So if you don't have that level of cover, then that wouldn't happen. I just wanted to point that out. Yeah.
Correct. Exactly. And I think, that is such an astute statement. I think where you are acting on sophisticated, transactions, the relevant clients, the lenders at the very least, will inquire as to the level of professional indemnity cover that, or they will accept a legal opinion. And really, a legal opinion is only as good as the professional indemnity cover that sits behind, that law firm. Otherwise, really, it's not worth the paper that it's written on.
Thank you. Fadekemi wants to know, in what context is a legal opinion required in a financing transaction as opposed to a due diligence report?
Like I said, really, a due diligence report does not actually provide any substantive cover, as it were. What the due diligence report does, it identifies what the relevant risks are in a particular transactions, and then it affords, in a financing transaction, not a corporate acquisition M&A, at least, because that's slightly different. But in a financing transaction, what a DD report does, it brings to light what the risks are, and then gives the parties the avenue and the opportunity to deal with such risks that have been flagged out in the due diligence report. And that could either lead to a change in the economics of the project, or the terms, the undertakings, the obligations of the relevant parties within the obligation, within the transaction. And I know this is not a DD session, and forgive me if I'm repeating what has already been covered, but essentially, for example, if you find within a due diligence process that the borrower is subject to litigation proceedings for which it has, $20 million at risk to be paid as a result of such proceedings, what you would want to do then is to make sure within the finance documents that the debt to equity ratio or the debt service coverage ratio is adjusted to ensure that if for whatever reason the borrower is made to pay out the $20 million or however much, it is still able to afford repayment of the loan. So that is the purpose of a DD process. So that just deals with sort of risk allocation and the negotiation of the contractual documents. But when it actually comes to a legal opinion, what you have as a lender, for example, or an employer on the construction contract is the certification or the assurance from a law firm with sufficient professional indemnity cover to say that actually the documents that we have negotiated, the parties that have entered into that document are actually authorized to enter into that document. They have the capacity to fulfill the obligations under those agreements, and the agreement can be enforced either by arbitration or by court. I hope that answers your question on the difference.
And I just think that what might help the person is also to know that one happens at the beginning while the other one happens at the end.
Yeah, correct. Exactly. So, like I said, really the DD process helps you negotiate your transaction documents. So by the time you are given a legal opinion, you've already done your diligence, you have already allocated risk based on the terms of your diligence report, and you have been, the terms are finalized. What the legal opinion does is right at the end to essentially ensure that whatever you've agreed and you've negotiated can be enforced, and the parties have the capacity and the authority to enter into those documents.
Thank you. Omolara wants to know what the best practice is for enforcing finance agreements when parties are from different jurisdictions.
What is the best practices for enforcing finance agreements when the parties are from different jurisdiction? Really, this is an interesting one, and really not one to do with legal opinions, while it's tangential, really, which is best sort of answered from a disputes perspective. But really, you need to follow the money. Everybody asks where, how, when it comes to enforcement, the most important thing is, where does the money sit? And really, what you need to do from an enforcement perspective, and those who are more concerned about enforcement are really the lenders. You need to ask yourself, how strong is my security package? and how liquid is my security package, and whether the assets that the borrower have or have access to sit. So you may have, for example, a UK lender lending to a Nigerian company, or even a Nigerian lender lending to a UK company. You would typically ask for controlled accounts that are situated in your jurisdiction as lender, or a neutral jurisdiction, and you would make sure that, you know, wherever the assets sit, you want to be able to enforce judgment in that, you know, in that relevant jurisdiction. I hope that's helpful.
Tola wants to know the extent of liability for offline legal opinion. Say, for instance, a call comes through from a client and he offers an opinion on the phone, a quick opinion on a transaction, something that is conceivable, and to what extent would there be a liability on his part in such circumstances?
I think that's a very interesting question, because, you know, as lawyers, we do give sort of informal legal opinions all the time, which is slightly different to sort of what we've covered during the subject matter of this presentation. In terms of your liability, again, I think the same principles apply. I think really your professional indemnity insurance as a firm is really on the line when you are given legal advice and legal opinions. Like I said, you know, distinction needs to be made between an employee of the law firm and partners in the law firm, because, you know, when you are given opinions or legal advice, yes, you know, you are licensed to practice law and you are given legal advice in that capacity, but really you sit under the cover of, you know, your law firm, whether it is sort of Templars, A&O, or Lani Wajae, whatever it is, as an employee of that firm, you are given advice. And again, the same sort of contractual and tort law principles apply. If as a result of your advice, loss is suffered, if as a result of your advice, which was wrong or negligent, and as professionals, we all have a standard to and a requirement to give accurate and proper and correct advice. So to the extent that we don't, and that results in loss, then we are potentially liable to negligence claims, which could, if the recipients of such advice decide to take it up in the court of law. But anybody you're giving advice to, again, this goes beyond the scope of legal opinions, but anybody you are giving advice to should be done under the scope and cover of a proper engagement letter, which sets out your liability limits, which sets out the scope of your advice, which sets out, you know, everything you need to do. So if somebody calls you randomly and asks for an opinion, you might want to make sure that you have a proper engagement with them first, or at least provide the proper and relevant disclaimers before giving a legal opinion.
Thank you. There's an interesting one here. It says, can the applicability of a legal opinion be made time-bound?
Oh yes, and that is the entire purpose of your assumptions and your qualifications. And in the context of this question, you would want to refer to your qualifications, which says this opinion is being given at the date of the opinion. This opinion is subject to the fact that searches, you know, may not reflect X, Y, and Z. So yes, certainly it can be time-bound.
And given the difficulties involved in searches in Nigerian registries, is it good practice to indicate the fact that searches themselves were outsourced to another law firm?
Well, that's actually a very interesting question. And, you know, I would I would really like to hear what, you know, a litigator's view of this is. I'm not sure whether that would be acceptable, really, because, you know, when you are providing a legal opinion, okay, from a matter of, you know, a proper and, you know, a pure construction sort of basis, looking at what the law is, it probably is acceptable. And if you state it there in black and white, that you take no responsibility for the searches, and, you know, it's on the basis of that, your opinion is being given on the basis of that qualification, then that is acceptable. But I find that sort of sophisticated lenders and people who are seeking these legal opinions will not accept that. So I think whilst, you know, it's actually quite smart where you are outsourcing the legal opinion, or rather the searches, to a third party to state it there that it is, you are relying on that result of those searches which have been outsourced.
If I may add, right, I think it will be generally counterproductive in the kind of transaction you're talking about for anyone to want to outsource it to anybody else. Because you see, I mean, you're being instructed specifically to carry out a transaction. Sometimes people outsource some of these activities because they want to save money. But I don't think that in the type of transaction that we're talking about, you want to even contemplate that. Yes, I agree with you. You could escape with that, but how does it make you look at the end of a transaction when you say, unless you have a transaction where clearly the due diligence was carried out by a third party, not yourself, and you want to issue that disclaimer. But if it is one that you were instructed to carry out, and you then purport to say, oh, a third party will bear liability for it rather than myself, I don't think that will help you even as a law firm going forward.
Correct.
Would you agree? I'll take that again. Where your opinion was disagreed with by your client and the contract eventually did not fly, as would have been based on this slight disagreement, what is the implication of this on your service?
Sorry, I'm struggling to follow that question.
So take, for instance, you give an opinion and your client disagrees with you and the contract falls through based on this disagreement. What is the implication of this on your service?
Well, your opinion is only really comes into force if it is signed and dated. And that is only provided after the agreements have been actually executed. You don't give an opinion on a transaction or a document that hasn't been executed, dated, and enforced, or at least subject to certain condition precedents being enforced. So I struggle to see or envisage a situation in which your opinion will have been provided in a situation where you don't have valid underlying documents to which their opinion relates.
Right. There's a question here. How much risk will a financier be envisaging when providing funding to a limited liability SPV?
How much risk will a financier be assuming when providing funding to a limited liability SPV? Again, you know, that is really sort of out of scope of this session on legal opinions, but to provide a response as best as I can, that it's, you know, I could probably write you a 40-50 page report on the risk that such financier will be taking, depending on its security package, the governing law, where the assets of the borrower, if any, because if you have an SPV, do they have future cash flows that are guaranteed by some sort of contract over a long-term period? Really, I think, this is the area where you would require significant due diligence to actually assess the affordability of the SPV. And typically you would not have a borrower, or rather a lender, lend into an SPV without guaranteed future cash flows by way of some sort of offtake agreement or a PPA, power purchase agreement, or any sort of agreement that guarantees a certain level of cash flow over a long-term period that allows the lender to get comfortable as to affordability. You have legal risks, you have commercial risks, you have technical risks. There is really a broad range of spectrum of risks that would need to be assessed when entering into a lending agreement to an SPV, which is why the due diligence process is so important. And like I said, I think it's important or rather it's helpful to think about it in heads of legal risks, economic or commercial risks, or technical risks, depending on the type of transaction within the sector. I mean, I'm happy to discuss this, and I can discuss this for days with whoever who's provided the question. But I think it's best we move on. But really, that is the scope of the diligence exercise, to identify the scope of risk and how you can mitigate such risk.
Ibrahim would like to know what the goal is for providing a legal opinion.
The goal is, providing a legal opinion isn't for the benefit of the provider. Really, law firms should avoid providing legal opinions because it's a risk for a law firm. What a legal opinion does, and what the goal is to provide comfort to the addressee that certain opinions with regards to matters of law relating to, as we've said, the capacity, authority, or enforceability of the documents as you understand them to be. So that would give you comfort to be able to, enter into that transaction as a lender or a procurer, whatever the case may be, and you will know that you can rely on the legal opinions to the extent that if such legal opinions turn out to be incorrect, you potentially have recourse against the provider of that legal opinion for negligence, or to at least give yourself a remedy. So it's for the benefit of the addressees and not for the providers. Whilst law firms do get paid to provide legal opinions, really you don't, it's not in your benefit to provide such legal opinions. Sorry, I think you're on mute, Mabel.
Oh, sorry. Jamilu said if there's any best recognized international request for due diligence checklist. More like a standardized.
Practical law is your friend. Practical law. I feel like we're talking more about DD than legal opinions. This DD chat must have been very, very, very interested. So when it comes to due diligence and putting a checklist together, there's a website called Practical Law that I would highly recommend, that provides really robust checklists that will be able to point you in the right direction.
Is there any
depending on your
relationship
transaction.
there any relationship between legal opinion on corporate financial transactions and assurance engagement?
Okay, so so you have legal opinions. So there are three things that I believe is mentioned in this question: legal opinions, corporate finance transactions, and assurance and guarantee obligations and transactions. Really, I think legal opinions and assurance and guarantee obligations will often form part of a wider corporate financing or a project financing or a general finance transaction. And within that general finance transactions, you may have certain obligations where you have guarantee providers for the underlying or the main facility, and to support that facility, you have legal opinions. So, like I said, you have the main corporate financing transaction, and then within that, you may have guarantee or assurance obligations related to that corporate financing transaction, and a request from the financiers to provide legal opinions in respect of the obligors. And what are the obligors? The obligors are the parties who have things to do in relation to that financing transaction, such as the borrowers or the guarantee or the assurance providers, etc.
Oh, there's this interesting one here. How would you charge the professional fees for a legal opinion? And what are the types of qualifications in a legal opinion? Did you get that, Ade?
Okay, for at least, I've given you at least, sorry, Mabel, what did you say?
Two questions. How would you charge for a legal opinion in terms of your professional fees? And then what types of qualifications are there in legal opinions?
Yeah, exactly. So I'm dealing with the second part of the question first. So with the qualifications, look at the slides. We've covered that.
Right.
And in terms of charging for the legal opinion, charge as much as you think you can get away with. If you think your client is willing to pay you $1 million for your qualification, charge $1 million. That's all I can advise on that one.
Thank you. Peter says, what's the scope of your disclaimer with respect to the advice you provide? For instance, when your opinion becomes counterproductive as a result of a new legislation coming after you have given out your opinion.
So, as I mentioned, one of the qualifications that you will include within your legal opinion is that your legal opinion is only valid as of the date you provide that legal opinion. So it is up to you as legal counsel to ensure that you know and you are up to date with every single piece of legislation that affects your legal opinion. So at the point at which you are giving your legal opinion, you need to be able to stand behind that legal opinion to know that it's up to date. If subsequently new legislation is put in place that changes or qualifies or alters your legal opinion, that's fine, because your legal opinion is only given as of the date at which you provided that legal opinion.
There's an anonymous question here. A legal opinion is supposed to guide the client in making an informed decision based on law. How then can it be given after the conclusion of the transaction?
Okay, a legal opinion, the purpose of a legal opinion is not to guide a client in making an informed. Can you hear me? Can you hear me?
Yes.
Mabel, can you hear me? Okay,
yes,
cool.
Yes.
The purpose of a legal opinion isn't to guide the client as to whether to enter into the transaction or not. that is not the purpose of the legal opinion, and that is not what we have been saying is the purpose of the legal opinion. The due diligence can be said perhaps to be the purpose of a due diligence report, but a legal opinion really is to ensure and give confidence to the addressees, the clients, and sometimes, you know, you're giving legal opinions to people who are not your client, that the obligations contained in the documents are legal, binding, valid, and enforceable, and those who have entered into the legal opinion, or rather the transaction documents, have the capacity and authority to enter into those documents. So it is not to give, a legal opinion does not actually assess the merits whatsoever of the underlying transaction or the risks pertaining to the transaction itself in a, you know, in a risk assessment perspective. Really, it talks to what the opinion is about, really capacity, authority, enforceability, otherwise of the opinion.
Thank you. I think I see another one here. And he says, should a lawyer expose any potential risk where the company stated that they do not have any personnel at the moment?
I'm not sure I follow the question fully, and you know, I'd need really sort of more context to provide a response. But I think, you know, in a nutshell, when providing an opinion, there is an underlying sort of level of diligence that is required as a law firm in order to give the relevant opinion. For example, your capacity and authority opinion, we mentioned that you need to have searches at the Corporate Affairs Commission or any other registry with respect to that company. Where you have taken out such searches and your opinions prove to be untrue, or there's some sort of level of risk as to the opinion that you are given, then simply put, you cannot give that opinion. When it comes to whether they have employees or they don't have employees, and this is probably more, you know, likely relating to the enforceability of an opinion, the fact that a company may not have employees does not mean that the contract it has entered into is not legal, is not the type of contract that is legal, binding, valid, or enforceable. It may mean from a commercial diligence perspective, they're unlikely to be able to carry out their obligations, but that does not mean that the document that they have entered to is not enforceable. But again, you know, I'll give you a practical example. You enter into a company with a special purpose company that has entered into contracts with an O&M contractor, with an EPC contractor, with, you know, certain facilities management contractors. That special purpose company may have 0 employees, but provided that they have the financing, provided that they have the subcontracts, provided that they have the offtake agreement, you know, everything can run smoothly. So the lack of employees in itself is not, you know, and again, we are talking about legal due diligence here and not legal opinions, but the fact that they don't have employees does not mean that they cannot fulfill their obligations under a transaction document. But again, that is probably one for the legal due diligence as opposed to the legal opinion, which deals with questions of law as opposed to questions of fact.
I must lend my voice to say thank you for a very brilliant presentation. It's 5 o'clock. I'll hand over to you to bring that.
Yeah. Thank you very much, Mabel.
Thank you.
Ade, what can I say? I mean, what a practical presentation you've given to us today. I mean, just thinking about it, if one writes legal opinions often, it could be a difficult proposition to ask someone to present a paper, but you've done it so articulately, and I think it's so intelligently presented. I also must commend you for the detailed nature of the paper, or rather the slides that you presented. And I'm sure that most of the delegates will find this very useful. Thank you very much. We're very grateful. We know how busy it can get out there. We're grateful to you for the interest in the development of our lawyers here in Nigeria. Keep doing what you're doing, and hopefully when we invite you again, you'll oblige us. Thank you very much on behalf of the Nigerian Bar Association. Thank you.
Thank you very much.
So,
it was a pleasure. Thank you very much.
Fantastic. So thank you very much, everyone, for attending. Tomorrow, we'll be focusing on security interests and security documentation. And I think that will be a very incisive session. And I encourage everyone to also log in tomorrow and participate. And finally, may I say that it's very important that we encourage as many members of, as many colleagues as possible to participate in these trainings, because where we're going to, whether we like it or not, it's only capacity that will save us. It's only being compliant and being competitive that will keep us in the game. So thank you very much for being part of today's session, and hopefully see you tomorrow. Take care and God bless.